Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
And Mr. Mills, in cause number 25 DCCR 0082, you're charged with the second-degree felony offense of assault on a peace officer. That's from November 19th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yeah, I understand that part, yes.
Okay, and I have a plea bargain here on the computer that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case go to trial and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plea.
Yes, ma'am.
You understand all of that?
I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am. Yes, Your Honor, ma'am. I wanted to reject it, and then I wanted to see, at that point in time, cause I was, I was in comfort at one point.
Okay.
I was out of my mind, which I have a history of it before.
Okay.
Mental health.
Okay.
But I just wanted to say on docket from everybody that in my mind, in my heart, my mind was so I would never hit office.
Well, so
Just a situation that I'm in.
The allegations allege alcohol and drugs.
and is there a video?
That's what I'm doing.
Hold on.
Oh, yes, ma'am.
I didn't see a video on Discovery. There may be, but I don't.
I have
didn't see
a
one.
thumb drive in my file, Your Honor.
Let me do this. So before we move your case to the trial docket, I'm going to let Mr. Parker have some time to get a copy of that video. And then he can come show it to you. You may not remember everything, but maybe that video will help you understand what happened and then see where we get from there, okay?
Thank you.
If you still want to go to trial after you see the video,
Excuse me, ma'am, Your Honor, I really don't want to go to trial.
well, that's what,
It's kind of,
I want you to see everything. I'll give them some time to get that taken care of. And then when you come back, we'll see what you want to do, whether it's a plea or a trial, okay?
okay, thank you.
All right, you can go back with the
And can I
bailiff.
ask you one more question, you mind?
Yes, sir.
In the situation, did probation ever come across the table?
That's between your lawyer and the district attorney's attorney. It's whether or not they offer
I
it.
wouldn't, okay, thank you.
Okay. I'm just going to delete the rejection if
Okay.
it's we'll do it again later if that's the case.
Okay.
All right. Good morning, sir.
Good morning.
Are you Samuel Jones?
Yes,
And Mr. Jones, in cause number 25 DCCR 0043, you're charged with the second-degree felony offense of burglary of a habitation. That is from November 21st of 2024. Your indictment alleges that you were previously convicted of fraudulent use or possession of identifying information, a second-degree felony, October 20th of 2021. And after that was final, you were convicted of theft of mail, a third-degree felony, December 12th of 2022. What that means is that if you go to trial in this case and you're found guilty, you would be considered a habitual offender, which means your minimum punishment if you're found guilty and the offenses are true is 25 years in prison up to 99 years or life. Do you understand?
Mm-hmm.
And I need you to answer yes or no, please.
yes, Your Honor.
Thank you. And I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that and have a jury decide if you're guilty and what your punishment would be if they find you guilty. I just want to make sure you understand what the possible... Okay, I just want to let me finish. I want to make sure you understand your consequences possibly and what your options are. And you want to reject that offer and have both cases. And so you also have, and let me go through this too, just for the record. In cause number 25 DCCR 0232, you're charged with burglary of a building, a state jail felony. And that is from January 5th of 2025. I'm assuming those same prior offenses are alleged in that one, which means in that case, if you're found guilty and those priors are true, the range of punishment in that case would be between 2 years and up to 20 years. Do you understand?
Yes,
Okay. And you want to reject that offer and have your case set for trial?
yes.
All right.
And
We'll
I'd
get,
like to indict everybody who have witness. I'd like to indict everybody who caused this case, signed the case.
Okay, so-
Fingerprints, evidence and everything. I want everything to be,
He's
everybody
complained,
indicted.
he's complained about some charges that other counties have explained that
Yeah,
doesn't have anything to do with
I'm
here.
So-
And he
so
wants
here-
everybody here, and I told him everybody will have to be here at trial whenever.
yeah, I mean, whatever the
Okay,
district,
well, I
listen.
want to let you know, I'm 17 code, my code is 774 is my badge number. 477, Barras, Bear County, Patrol Detention Center. I'm a
Okay.
private detective and everything,
Okay.
private investigator.
All right. So here's what we're going to do before we move any further with this is I'm going to, Mr. Jones, I'm going to have someone talk to you to make sure you're competent to stand trial, get all your history, make sure we're all good before we go to trial. When they visit with you at the jail, either in person or on the computer, you need to make sure and cooperate with them, and then we can move your case forward, okay?
Yeah, it'll be fine.
All right, go back with the bailiff, please. Everybody keeps, y'all just wait, I'm gonna get everybody. All right, are you Evan Bowden?
Yes, ma'am.
Mr. Bowden, you're charged in each of your cases with evading arrest or detention with the use of a vehicle, and what is the announcement?
Your Honor, this is the case where he also has a pending motion to revoke probation out of Chambers County. I've been trying to work something out with him. The prosecutor handling that case is Eric Carcerano, who's currently in Austin for trial legislative issue right now. I call it.
This is,
I know, but if I plea him out to this, Your Honor, that's automatic revocation over there, and he's gonna get the back. I know it doesn't affect this court, but it does.
I mean, you've been
me.
on the case since June of
Oh,
last year.
I know.
So here's what I'm gonna do, I'm gonna reset it 2 weeks.
Oh, that's fine. It should be fine,
And
yeah.
that is the final reset.
Like I said, there is-
Hold on, it's either going to trial or it's going to get taken care of on that day.
So I'm saying, the offer that the state's made, we want to accept. We like it. It's great. It's just a matter of I don't want to do something here that's going to automatically send them up there.
Well, there's
Once I get
been,
the-
I'm
I
sure
know.
he hasn't been in Austin this whole time.
No,
so-
it's just been since
all
our
right.
last resetting.
All right.
So,
You can go back with the
but,
bailiff.
yeah, we'll get something done in that amount of time.
Mr. Flemings, and is it the same in each case, or was it an agreement for a dismissal in one, or?
It was intended to run concurrent about 8 years.
Okay, and did you do two pleas? Okay, they're both here? Okay, I'm sorry, I just saw one. Mr. Flemings, in cause number 24, DCCR 2144, you're charged with the second-degree felony offense of assault on a peace officer from September 11th of 2024. That indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, September 27th of 2023. And what that means is that if you go to trial and you're found guilty and that prior offense is true, the range of punishment would be between that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand?
I'm sorry to interrupt.
Yes.
Your Honor. I believe the defendant's criminal history lends itself to being a habitual offender, and I have every intention of filing the habitual offender notice.
Okay, and Mr. LeBlanc, did you go over that with him as well?
No, you and I talked about that outside.
Oh, as far as the.
25 to 99. Yeah.
So, the state has information, he says, that you have more than one felony conviction from before. So if that's true, if you have at least two that are from different dates, and you are found guilty, that changes this from a first degree up to a habitual offender status, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand? And in cause number 24 DCCR 2145, you're charged with the state jail felony offense of injury to a child, elderly, or disabled, individual from September 11th of 2024. That indictment alleges several prior state jail felony offenses. And when I say several, I mean 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior state jail felony offenses. It does not allege those prior regular felony offenses, but if you have, again, two regular felonies that are sequenced, not on the same day, in that case, it would make it a second degree felony offense for punishment purposes, which has a punishment range between 2 years and up to 20 years. Do you understand?
Judge,
And-
I'm sorry to interrupt again. I want to correct the record. I misspoke. Mr. LeBlanc and I talked about it being enhanced to a regular first degree.
Okay.
5 to 99. We
Okay.
didn't specifically talk about the 25 to 99. I don't want to.
Y'all didn't, but you do have the prior, so it could be. Y'all just didn't discuss it.
Yes, ma'am.
Okay, so, but you understand now, I've admonished you, and you understand, and you know what your history is. If you have a prior felony, two prior felonies that aren't state jail, and you're found guilty, then the minimum punishment is 25 years. You understand? And that's on the assault case of a peace officer, and the other range of punishment in the injury to a child would be 2 to 20. You understand?
Yes, ma'am.
Okay, and so I have here on the computer plea bargain rejections that you've signed with Mr. LeBlanc that shows that the district attorney's office has made an offer of 8 years in each of those cases to run concurrently. which means at the same time. You have every right to reject that and have your cases set for trial. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. LeBlanc will begin preparation for trial. You can go back with the bailiff. Ms. Bean, in cause number 23, DCCR 2068, you're charged with theft of property in an amount more than $2,500 with previous convictions, which is a third-degree felony, from April 6th of 2023. The indictment alleges you were previously convicted of theft September 4th of 2014, December 22nd of 2015, December 6th of 2017, December 7th of 2018, and June 24th of 2019. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? And then in cause number 23, DCCR 2069, you're also charged with theft of property with previous convictions in an amount more than $2,500 from June 25th of 2023. And how do you plead to that charge? That's also alleges all of those same prior offenses. And are all of those same prior offenses true? And in this case, did you enter your plea of guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Bean is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 23, DCCR 2069, find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions in an amount above $2,500. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that the law gives you the right to receive. In addition to that, I will give you credit for any from the date of indictments in each of these cases, which is from November 29th of 2023. So you will receive credit from November 29th of 2023. Y'all have marked that on here as 624 days. I'm going to assume that y'all did that math correctly. But it's for sure from the date of indictment on each case. Do you understand? And then in cause number 23, DCCR 206, which one did I just do? That I made the finding? Okay. In 23 DCCR, you good? Sorry. 2068, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of theft with prior convictions in an amount above $2,500. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Correction. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive, and also specifically from the date of indictment, which is November 29th of 2023. These two cases will run concurrently, which means together at the same time. I have handed you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right? Good luck to you, ma'am. You can go back with the...
As the courtroom doors close on today's session, we're left with stories that prove just how unpredictable justice can be. What began as routine hearings quickly unfolded into moments of tension, shock, and life-changing consequences. We saw Warren Mills stand before the judge, facing the weight of an assault on a peace officer charge. A deal was on the table, but he rejected it, convinced he wasn't guilty. His claims of being mentally unstable, of not remembering his actions, painted a picture of desperation. Yet, when drugs and alcohol are in the mix, excuses rarely carry the weight of evidence. For Mills, the stakes remain high. 2 to 20 years hang in the balance. One decision in court, one video, one jury, could shape the rest of his life. Then came Samuel Jones, a name tied to more than one felony. And here, the law showed no mercy. Labeled a habitual offender, his minimum sentence skyrocketed to 25 years. That's not just a punishment. It's practically a lifetime. The courtroom went silent as the judge explained what that meant. Justice, in this moment, wasn't just about the present charge. It was about history, about patterns, about the law drawing a hard line. Do the mistakes of the past define the man forever? For Jones, the law says yes. But just when the gavel seemed to be falling hardest, we witnessed a rare shift. Kenneth Cole, a defendant who had stumbled again and again, failing probation requirements, missing expectations, still walked out with a lifeline. Instead of locking him away, the judge extended his probation. A gamble, some might say. Mercy in a system built on order. It was a chance for redemption, but also a warning. One misstep, and prison doors await. These cases remind us that the courtroom isn't just a place of law, it's a stage where lives are rewritten. Some find second chances, others face decades erased by their past. And as we watch, we're left to ask ourselves, what is justice? Is it strict punishment, or is it the hope of rehabilitation? One thing is certain. Every word spoken here, every judgment delivered, echoes far beyond these walls. Families are changed, futures are sealed, and society itself feels the ripple.